topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Tampa. Welcome to another Ask the Expert show, where we always bring you the finest experts in the field of legal, health, financial, and home improvement. I've always got the last Tuesday of the month circled because there's three shows: the last Tuesday, the last Thursday, and the first Thursday of the month, because it's our K Bender Rimbaum hour. It is like the easiest show for us to do. We know that we have so many listeners out there that are part of community association that have questions, and here we bring one of the top community association law firms on our show, and we're so glad to have back an old face attorney, Kirsten Hintz. Good afternoon.
Well, hello, Steve. Thanks for having me.
Can you hear us?
Yes. Can you hear me?
Yeah, I can hear you now.
Okay.
Yeah, in fact,
Thanks for having me.
we actually had a couple people say, what happened? Some of our listeners, what happened to Kirsten? You have been busy. You guys do so many trade shows, and you're out there educating the public. But we're so glad that you're here with us today.
Yes, thanks, Steve. Yeah, I mean, there were a number of trade shows that unfortunately conflicted with the radio show and took me out of commission. But here I am. I'm back.
I am so glad. Kirsten, tell people about K. Bender Rimbaum.
Sure. Well, for those of listeners who are not familiar, K. Bender Rembaum is an association, community association law firm. So we represent condominium, HOAs, and cooperative associations in the state of Florida. We have close to, I guess, 23, 24 attorneys throughout the state of Florida. And we have multiple office locations. Our main office is located in South Florida in Pompano Beach. And then we have an office in Palm Beach Gardens, Orlando. And then on the West Coast, our office is located here in Tampa, which I manage.
Well, I got to tell you, K. Bender Rimbaum has got such an amazing reputation. See, we do the show all over the country, and we actually have two other large law firms in other states that do community association law, and the name K. Bender Rimbaum really stood out to them as one of the top law firms, not only just in Florida, but in the country when it comes to community association. So I thought that was really cool that
is cool.
Other large community association
Sure.
firms in other states think you're the best.
Oh, that's awesome. Well, thank you.
So
well,
what
we've been around for a while, Steve. We've been around for a while, so it's no surprise. But thank you.
But you've made a huge imprint in the market, and people respect you. And they, it's so. I always compliment Robert Kay, the senior partner, that how important is educating people on what you do, because laws are always changing. People have all kinds of problems, and you're always out there in the community educating people.
That's correct, Steve. I mean, We're constantly doing webinars. We conduct webinars, seminars in person. And then we also attend these trade shows, right, where there's opportunity for teaching and for board members and managers to attend. And the best part, Steve, is all of these webinars and seminars are free of charge. We do this because we love to educate the public. We love to educate board members, managers. There's nothing better than having an informed board member, right? So.
Absolutely. And the state, I guess, changed the length of time to get certified. When you go to your certification classes, they're a little bit longer now, right?
Yeah, there have been some changes to the certification requirements, and for HOA board members, especially, the requirements have increased. So not only do they have to, board members in an HOA, do they have to do their board certification within 90 days of being elected or appointed, but they have also continuing education requirements, and the hours, the number of hours that they have to attend will depend on the number of parcels in their community. So if the community has less than 2,500 parcels, well, they have 4 hours of continuing education to do every year after they complete their board certification class. And then if the community is larger than that, well, they have up to 8 hours to complete. So it's crazy.
Well, how we work this is we gather your questions. People send in questions throughout the month, and then we relay those to, uh, in this case, Kirsten. And we also have a chat line. If you're watching or if you want to call in, we have a chat line for your questions. It's amazing. I've been doing this for 15 years. I have never seen a show that gathers so many questions as this one does. So let's get at it. And I promise you, we will get to your schedule. You have a schedule of classes that are coming up. We will get to that in a few minutes. Let's start off with Richard in Mango. What is Kaufman language? I know this is not a quick question.
Oh man, Kaufman has had a lot of popularity recently. But Kaufman language refers to the magic words as amended from time to time, which you'll find referenced after either reference to Chapter 718 or 720 of the Florida statute. And I always tell board members, typically, if you open up your declaration, whether it's the declaration of condominium, if you're in a condominium association, or the declaration of covenant, if you're in an HOA governed under Chapter 720, but typically in the first few pages, there will be language, something to the effect of that this community is developed and is governed under either Chapter 718 or 720, and then it might have as amended from time to time. That's what Kaufman is. And what that means is if you have the Kaufman language, it means that changes in the statute, whether 718 or 720, they will apply to your community. Now, I want to clarify, there's two types of changes that the legislature makes to the statutes, substantive changes, and then there's procedural changes. Well, substantive changes affect the vested rights of owners, right? So changes, for example, that went into effect in July regarding the parking of commercial vehicles in HOAs. These types of changes we would consider substantive changes. Well, if you have Kaufman language in your declaration, substantive changes to the Florida statute will apply to your community without having to amend your declaration. So those communities that do have Kaufman, unfortunately, would be subject to these commercial vehicle restrictions. Now, if you don't have Kaufman language, right, on substantive changes, the constitutional argument that the association could make is that changes in the statute that took effect recently, they won't apply retroactively to the community. And that's because a very basic premise in the law is that the legislature cannot pass laws that retroactively impair contractual rights. Well, as you may know, the Declaration of Condominium and Declaration of Covenants is a contract between the association and owners that buy into the community, right? And so the legislature can't just come in and modify that contract by passing laws. So if you have Kaufman language, substantive changes apply retroactively. If you don't have Kaufman language, well, you can make an argument that substantive changes do not apply. And so you're bound by the laws that are in effect at the time that the declaration was recorded. Now, procedural changes, right? That's another type of law that legislature passes. And procedural changes, an example of that would be, for example, in the condominium setting, laws that address elections. Right? Everybody knows that in condominiums, elections have to be done, with the first notice and a second notice and so forth and so on. And so when the legislator makes any changes to, for example, that might affect elections, well, those are procedural changes, right? So it just affects, the procedure, how things get done. Those type of changes will apply to the association, regardless of whether there's Kaufman language in the declaration. Another example of procedural changes would be, for example, fining. Right, the statutes allow association boards to fine. And so changes to fining procedure, again, would also apply retroactively to communities, regardless of whether you have Kaufman. So it's a complicated concept. And so my suggestion is, if you have any questions as to whether any section of the statute applies to your community, seek the guidance of your legal counsel.
Somebody just wrote in wanting to know, is Kaufman language just for condos or is it for HOAs also?
No, Kaufman applies for both condominium and HOAs. And again, it just refers to the language as amended from time to time.
Rocky in Tampa wants to know, how far in advance do condo election notices need to go out and what information needs to be on there?
Well, for condominiums, they are a creature of statute. So elections have to be conducted in accordance with Florida statutes and the Florida Administrative Code. So Florida statute requires 2 notices to be sent out for condominium elections. There's the first notice, what is referred to as the first notice, and that has to be sent out to the owners at least 60 days prior to your annual election meeting. Now, the notice can be sent out either by mail, hand delivery, or it can be electronically transmitted to those owners who have consented to receiving notices by email. And the first notice will typically just include the date, the time, and the location of the annual meeting. It might include reference to anyone desiring to run for the board, must provide their notice of intent to run by a certain time frame. And so the first notice will typically include those deadlines. Owners who want to submit an information sheet, which is typically, a 1-page bio about themselves and why they should be elected to the board. Well, there's statutory deadlines for submitting those information sheets as well. And so the first notice might include a deadline for that. And then the second notice that would need to be sent out with a condominium election is what is referred to as the second notice of the annual meeting. And that has to be sent out at least 14 days prior to the annual election meeting. And that notice is going to contain not only the date, time, and location, but will also include the agenda items for that meeting. So election of directors will have to take place, or typically takes place on the date of the annual meeting. But the board might have other agenda items. Typically, this is a good opportunity to present any issues before the membership, issues that the owners need to vote on. And so, if you have any issues you want owners to vote on, that will typically be included on the agenda of the second notice.
We just got a text show. I am 67 years old. I am looking for a new home. Do the communities that are 55 plus, do they have different rules for their association than other associations?
Well, it's a broad question. Communities that are that qualify as housing for older persons, those that typically referred to as 55 and older,
Right.
they have the age restriction that other communities are not really allowed to have unless they qualify as a housing for older persons. And there's certain requirements under the law that the association has to comply with in order to qualify, right? Because you can't discriminate based on age. So if you are looking to buy a home or a unit in a housing for older persons community, expect that there would be age restrictions, not so much on the ownership, but on the occupancy of the property. So at least one individual has to be, 55 and older. You could have someone, between the ages of 18 and 55 reside there, but you have to have at least, one other individual who's 55 and older. And then children under the age of 18 cannot permanently reside in those types of communities. They can visit, and I'm sure those communities have their own rules as to the length of time that children under 18 can reside, but generally they can't permanently reside in those communities. Those would be really the main distinctions. I don't know, every community is different, so there could be other restrictions.
But they allow kids to visit, like grandchildren to visit.
Yeah.
Okay. Let me go to Jerry in Tampa. And I want to thank everybody because it's really important we know when you send a question in, if it's a condo or HOA, it does make a difference. So we appreciate a lot of people who are writing in or telling us. Jerry in Tampa, our term limits are in May. I'm a condo board member. How long can a person sit on the board?
So it sounds like their annual meeting happens around May. Well, I mean, term limits it's really going to depend on the bylaws of the community. So the bylaws will typically dictate if board members can serve for 1 year or longer than a year. So my suggestion is just take a look at the bylaws to see what the term limits are.
Kirsten, I get a lot of letters that people they're having a hard time getting people to become a board member. And I guess it's not so easy getting people to come sit on the board. But, if you care about your community, it's a great way to make things happen, right?
Yeah, I mean, I'm hearing that as well, even from some of our clients who are having a hard time, getting volunteers to serve on the board. I think certainly the certification requirements have dissuaded a lot of individuals from running or serving on the board. But I think it's important to highlight that in order for the association to operate, right, to conduct business, you have to have at least a quorum of the board seated, right? So if you have a board of 3, you have to have at least 2 directors at all on the board at all times in order to be able to conduct business. So if you're in a situation where you have less than a quorum of the board, then you don't have a functioning board and you technically can't operate, right? And so if you're in that situation, that's potentially problematic. And so you might be looking at a receivership situation. So, with the receiver, essentially the court will appoint a third party to conduct the affairs of the association until you can get enough members on the board. With receivership, it's expensive. It's an expensive proposition. It costs money. Sometimes, I don't know, $200, in excess of $200 an hour for a receiver to assist. And so you don't want to be in that position.
Right.
So to the extent that you can control this, yes, try to get volunteers to serve on the board.
I think people are worried that they're not qualified. And I think you can explain that better. There's not a qualification.
Yeah, I mean, you have to be at least 18 years old.
Yes.
Right? So most individuals would qualify. You don't need a specific background. I mean, from my experience, many of the board members, were professionals at some point in their lives. So, that I think automatically qualifies you. But, under Florida law, under the statute, there's really not a lot of qualifications other than being 18 years of age. You can't have a felony conviction. And if you've had a felony convictions, you need to have at least 5 years. Your civil rights need to have been restored. And you can't be delinquent. I mean,
we get a lot of people ask that.
Yeah, as it gets. I have seen where specific communities might have qualifications in their governing documents and their bylaws. A common one is, you have to be a resident of your property at least, 6 months out of the year. If you have that type of qualification, because it's not in the statute, you might have a problem enforcing it if legally challenged. And so, I mean, other than that, it should be pretty easy to get on the board.
Well, we're going to go to a break. Somebody just wrote in, Kirsten, I love your new hair color. See, you've got fans, I'm telling you.
Why, thank you. Thank you.
First, before we go to break, give people the schedule that you've got coming up for your classes.
Okay. I mean, we have April seems to be a busy time for expos. So Broward County is having their expo April 3rd. We have the Tampa Expo. So for those who are on the West Coast in the Tampa, Sarasota area, we have ours coming up April 16th. And then those that are in the Palm Beach area, the expo will take place April 22nd. And then we have a few classes scheduled in April. I'm going to be teaching the condominium board certification class on April 8th, and that's going to be on a webinar from 11 to 3 p.m. Remember, folks, the condo board certification class is supposed to be 4 hours, so it is a long one. Then on April 10th, attorney Emily Gannon will be teaching the HOA board certification class. So that's April 10th from 12 to 3 p.m. That one doesn't, under the statute, doesn't have to be 4 hours. We typically can complete the webinar between 2 to 3 hours. So about 2.5 hours typically with Q&A. And then let's see. Oh, I'm teaching on April 22nd, a class on updating your governing documents. That's always a very popular one. So I'll be answering questions and talking about the process of amending your documents and what you should be looking for in your documents to amend. Then one of our senior partners, Jeff Brembaum, will be teaching a class on construction contracts and funding construction projects. That's a good one. That's going to be in Palm Beach, Seasons 52 restaurant. And then another one of our attorneys, Chris Posner, will be teaching April 24th a class on covenant enforceability. And that's what we got going on in April.
Beautiful. We're going to go to break now. Tell people how they can reach your office in Tampa.
Sure. I mean, all of our offices can be reached through the main line, and that's 954-928-0680.
We're going to go to break. We'll be right back with more. Kay Bender Rimbaum and attorney Kirsten Inns. We'll be right back.
Kay Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several Kay Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. Kay Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact Kay Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is our Tampa show. It's the last Tuesday of the month. We're here with attorney Kirsten Inns. We got a question from a listener who want to know what can be done if a renter smokes marijuana for medical reasons and offends a number of the neighbors. We suspect he is dealing drugs to strangers as people come all during the night. Can we request a stranger show ID if we did not request it for others? We have contacted the police, no help from our condos. What do people do with it, for even if it's just regular cigarettes? What can people do?
Well, smoking, typically condominium documents do not, and I presume this is a condominium, right?
Yes.
Unless you amend your documents to expressly prohibit smoking in units, most documents don't really prohibit smoking, right? And so you're almost forced to, address the issue under a nuisance provision. I mean, that's an option, right? So you can't conduct yourself in a manner or create any nuisance, right, to the rest of your residents. But in order for the, violation to raise to the level of a nuisance, it has to affect more than just one resident. So it can't just be that the neighbor is the only one that's complaining to the association of the smoke, right? It has to be more than one other resident. Otherwise, the association would just not have any basis to really get involved. I guess with the marijuana, you got to be a little bit, it's a little sensitive issue, right? Because
Yes.
if the resident or the occupant says that this is medical marijuana, they can request an accommodation, and you just have to evaluate that request, just like you would with someone who's requesting an assistance animal, right? An emotional support animal. So, you can send a demand letter and let the resident respond back saying it's medical marijuana, and then you'd have to follow the fair housing procedure for providing an accommodation. So speak with legal counsel on the best procedure in that regard.
Kirsten, do associations have special rules for renters?
Well, I mean, it shouldn't be special rules. A board can adopt rules regarding conduct. I don't know that they should be specific to renters. It should be really conduct about any resident in the community, right? There might be specific requirement for tenants. I would expect to find those in the declaration rather than rule. But if we're talking about just general conduct, the board can adopt general rules.
Okay. Let's go to Connie in Lutz. There's really a city called Lutz.
Lutz.
We did.
Yes.
Lutz.
I live not too far from there.
Really? So
Yes.
We did our reserve study. I thought we were fully funded. What does fully funded reserves actually mean?
Okay, I presume Connie's in Lutz. I presume Connie is in a condominium association. Fully funded means, let's take the example of roof replacement. So, and we're talking about non-SERS reserves, your basic reserves that every condominium association has to reserve for, which is roof replacement, building painting, paving, and then any other item that will cost more than $10,000 to replace. So if, let's say, the roof of your building, if you've done a reserve study and the study says that you have 10 years left on your roof, on your building roof, and it's going to cost $100,000 to replace that roof at the end of that 10-year useful life. Well, then that every year for the next 10 years, you have to collect $10,000 towards reserves. Right. So fully funding means that you want to have the full funds that you need to replace that roof at the end of that useful life. Right now, reserve specialists, engineers, they have a way to calculate this, and it accounts for inflation, et cetera. So speak with your reserve specialist. But that's what fully funded means. Now, the board can give the owners the option to waive or reduce the funding of those reserves, right? To partially fund those reserves. That's a business decision of the board, if that's what the board wants to do. But it would take the vote of the owners to either waive or fund anything less than fully funding in any given year. And the statute was amended several years ago to now require vote of the majority of the voting interest to partially fund reserves or waive reserves. So just be aware of that.
Okay. John in Clearwater, he said, we have been flooded 3 years in a row. We're now researching flood control. Will that require only the people on the first floor, or does everyone have to participate? Is this considered a repair? Good question. I guess they feel like the only people being flooded are the ones on the first floor, and they want to know, do they have to also pay for the funding?
Well, a good example in a condominium is there. Let's say there's an elevator in this particular condominium, right? And you're an owner that lives in the first floor unit, so you don't have to use an elevator. And let's say
Right.
we all know elevators shut down, they need repairs,
Yes.
and after so many years, they need to be modernized, right? And it could be several $100,000s to modernize an elevator. So does the fact that the owner on the first floor doesn't use the elevator, does he get to be exempt from assessment on that, or the cost of modernizing or repairing the elevator? The answer is no, right? It's a common expense to everybody. So, unless the declaration says something otherwise, typically, repairs to these first floor units would be a common expense to all the owners. But again, that's a question that I would
Makes sense.
suggest, consulting with the association counsel on that. Yeah.
Kirsten, you would not believe how many letters we get from owners who are saying the elevator's been broken and it hasn't been fixed, and what can we do? We get a lot of letters with that.
I was just
Speaking
in
of
one the
elevators.
other day. It was working. It was going up and down, but the lights weren't working. So
Oh,
it was a bit of a scary experience.
yes, really. No kidding. Robin in Tampa, thank you so much for sharing so much legal information each month. I want you to know people really do appreciate you coming on each month. Can you have too many claims where we could lose our association insurance?
I mean, it's possible, but that's not so much a legal question. I think that's more of a question to pose to the association insurance agent. I know board members are always concerned, if they make too many claims, or are they going to be denied for coverage?
Yes.
On the one hand, you are required to have insurance, and it's good to have insurance, and that's what insurance is for, right? So you have coverage. On the other hand, too many claims could potentially, be a problem. So I would suggest just reaching out to the association insurance agent and posing that question to him and her.
Carl in St. Pete, HOA. What is the authority? We get this question a lot too. What is the authority of the Architecture Review Commission?
The Architectural Review Committee. Well, I mean, typically their role is to review requests for exterior changes to the parcel, and then determine if these requests conform or comply with the architectural standards that hopefully are in place in the community, and either approve them if they're in conformance or reject them. That's the general role. Now, the governing documents might give the Architectural Review Committee, additional powers, such as the power to adopt standards, right? What color can you paint the exterior of your home? What kind of windows you can install, etc. And so, if the documents grant the ARC this power, then they can adopt these standards. So that's generally what they do.
Karen, and I'm so glad you told me how to pronounce Lutz. Karen and Lutz, many of our owners are aging out. Can the adult child serve on the board? These are condos that are handed down to the children. Do the children have any rights in the association?
Well, I think what Karen is asking really is, do these children qualify to serve on the board? And again, the qualification would have to depend on, depends on your governing documents. Whether or not a director or board member has to be an owner, or a family, a relative of the owner, that's going to depend really on the bylaws. And I've seen them. I've seen qualifications where a board member has to be the record owner or the spouse of the board member. So it just depends.
Sal in Tampa is a condo owner. He said if a condo year is from January to December, when is the budget supposed to be finished?
All right, so he's referring to the fiscal year. The fiscal year for this particular condominium runs from January to December. So the condominium statute was amended a few years ago to now provide that the budget for a condominium has to be adopted at least 14 days before the start of the new fiscal year. Now, if your bylaws provide something else, if your bylaws require you to adopt a budget, 30 days before the start of the new fiscal year, then you go with that. But under the statute, it's 14 days before the start of the new fiscal year.
Ken in Mango is a condo. He wants to know, this is what we were just talking about before. If no one runs for the board, do you have to have an election? We are 121 units, and we're lucky if we get 20 people to show up. We were just talking about that.
Yeah, that's exactly. Well, I think if for condominiums, there is a deadline by which individuals who want to run for the board need to submit their notice of intent to run. So I think if by the time that deadline rolls around, if you have 0 notices of intent to run by then, I think that's a problem. And you might potentially be looking at, rescheduling your election until you can get someone to run. You never want to be in this position. So I would even say, plan in advance for your election. If you have a date already set, even before you send out your first notice, start advertising, right? Sending out newsletters, knocking on doors, letting people know that election's coming up. So run.
Carrie and Brandon, love your show. Oh, look at our staff watches every month. This must be a board member. Can our annual meeting be done by Zoom? We get a lot of those questions.
Well, you can offer Zoom as an alternative option, right, for owners to log in and watch the annual meeting. But especially for condominiums, you need a physical location for your annual election meeting. And one of the reasons is because with condominium elections, as your listeners might know, ballots, and if they don't know, they'll learn it now. Polls do not close for condominiums until the first outer envelope is sliced open, right? So after the outer envelopes have been verified, and you start slicing through those outer envelopes, that's when polls officially close. So you have to allow owners to come in and drop off their election ballot up to that point. And if you don't have a physical location where that can occur, that's potentially problematic and can subject your election to legal challenge. So especially for condominium associations, you need to have a physical location for your annual meeting, and then just offer Zoom as an alternative.
Okay. Cal in Tampa wants to know, can people running for the board send out bios?
Yeah, I mean, and they're referred to as information sheets. Yes. Okay. There's a deadline for submitting information sheets. And then if a candidate did submit an information sheet, then they have to be enclosed with the second notice that goes out to the membership at least 14 days prior to the meeting. And let me tell you, we've had even clients who, forget to enclose these bios or info sheets with the second notice. And, that's problematic, right? Depending
Right.
on whether you've missed the 14-day deadline or not, it might even require you to either resend an amended second notice or even redo the whole mailing. So make sure that you enclose those information sheets.
Sharon in Clearwater, she is an HOA. I think we just talked about this before, unless it was for condo. If I am delinquent, can I still run for the board, HOA?
So with HOAs, no. If you're delinquent on any monetary obligation, by the time by the last day by which you are allowed to nominate yourself for the board, then no, you're not qualified to run.
Okay. Jill in St. Petersburg, can we do our annual and our budget on the same date?
Yes, an association can have their annual meeting and have the budget adopted on the same date. I want to clarify these two things, though. Remember, the budget is typically adopted by the board. It's not something that's typically adopted by the membership. So because it's adopted by the board, that requires a board meeting. The annual meeting is a membership meeting. It's a meeting of the owners. It's not a meeting of the board, right? So if you are going to have the budget adopted on the same date as the annual meeting, then my suggestion is to have your board meeting at which you can adopt your budget first, right? Adopt your budget, adjourn your meeting, and then go ahead and call the annual meeting, because that's the meeting at which you're going to have your election, and you can potentially have a turnover of the board, and new directors might be seated. So you're not going to be able to adopt the budget at the annual meeting. So adopt it first and then have your annual meeting. That's totally acceptable.
Okay, Kelly in Tampa, condo. Can a condo owner ask questions at a general board meeting?
Well, I don't know what is a general board meeting. I mean, typically all board meetings have to identify agenda items, right? That are going to be discussed at the meeting. So under Florida statute, owners do have the right to speak as to any designated agenda item, as well as to ask questions really on any issues affecting the condominium. So yes, owners can ask and speak at board meetings.
Just got a text. They want to know that what if we are having problems getting board members? Does a board member have to own property?
Does the board member have to own property?
Does he,
I wonder
does
if
he
they
have
can
to?
own the unit.
Yes. You have to
Right.
live there to be a board member.
Well, those are two different things. If the question is, does a director have to be a record title owner of a unit? That's going to depend on the bylaws. If the question is, does the director have to be a resident? I mean, also that's a qualification requirement that would be in your bylaws.
Okay. Sally wants to know, sort of touched on this too. Can you talk about the process of elimination of smoking in common areas?
Not sure what the
Sounds
process
like
of elimination
sounds like
is.
they want to sounds like they want to get rid of smoking, period,
Smoking, yeah.
outside.
Well, the board can, provided the documents give the board rule-making authority, right? The ability to adopt rules regarding common areas. The board could adopt a rule prohibiting smoking in the outdoor common areas, like, the pool deck, whatever other common areas the association might have. The more difficult one is trying to eliminate smoking in units, which will typically require an amendment to the declaration, which typically requires owner approval.
I got to tell you, I know why Kay Bender gives you so many of these classes to do, Kirsten, because you do such a great job. The show goes by so fast. Give people again the phone number if they want to contact the office.
Yes, the main number for all of our office locations is 954-928-0680.
What a great show. I mean, your shows always go by so fast. We'll see you next month. Hopefully.
Yes. Thank you so much for having me. It was fun.
Thanks, Kirsten.
See you then. Bye-bye.
That's Kirsten Hens. She's one of the attorneys at K. Bender Rimbaum. Now, that's it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.